I can type them in here.
Good afternoon, everyone. I'm going to wait a few more moments to make sure everyone's connected with their audio and, if necessary, video, and then we'll get started. All right, I'll go ahead and get started. Good afternoon, everyone. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board, and I realize all of you have been together many times, and this is my first instance of presiding over this proceeding, so my pattern might be a little different, and we'll all get used to it together. So I appreciate your patience. But this is what I'm calling a pre-hearing conference in the court reference proceeding in the case of City of Marina versus RMC Lonestar. That's Monterey County Superior Court case number 20CV001387. It is, looks like 1:03 p.m. in the afternoon on September 7th, 2023. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. The audio and video are being recorded, and we will post files of this recording to the AHO FTP site, and the YouTube recording will also be available on the AHO YouTube webpage. If you are experiencing any technical difficulties today during this conference, trying to communicate with us, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring that email inbox and can let me know. As is typically the case, assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Skylar Anderson, Kyle Wooldridge, as well as Regina Graziano with the Office of Research Planning and Performance. I'd like to move to appearances. I'm not sure how you've done it exactly in the past, but the way I like to do it is just to identify each of the entities who are participating on the service list. And if you are representing that entity, please introduce yourself. This will be a good way. I mean, I've been watching the proceedings. So in some ways I've met most of you and can identify you, but this is a good way for us to all get to know each other before we meet again, whenever that may be. So I'm going to start with Cal-Am Water Company. You can proceed in any order you'd like in terms of introducing yourselves.
Good afternoon. My name is Bob Moore, Alan Maxis, and I'm representing Cal-Am.
Thank you.
Good afternoon. My name is Michael Betts, also with Alan Maxis, representing Cal-Am. Thank you for your time.
Thank you. Good afternoon.
Good morning, Ms. Kinsey. Robert Donlin, representing Cal-Am.
Good afternoon. Catherine Horning with Cal-Am.
Thank you. Good afternoon.
I would note with us, and I don't see, is our three experts. We have Mr. Tim Durbin, Mr. Pete Leffler, and Dr. Johnson Yang.
Thank you very much. I appreciate that. Thank you. With that, I will turn to Marina Coast Water District.
Good afternoon, Ms. Kinsey. Kyle Brochard, on behalf of the Marina Coast Water District.
Thank you. Good afternoon.
Good afternoon. Chip Wilkins with Remy Moose Manley from Marina Coast Water District.
Thank you. Good afternoon, Mr. Wilkins.
Good afternoon. Christina Bergland with Remy Moose Manley, representing Marina Coast Water District.
Thank you. Good afternoon, Ms. Bergland.
Good afternoon, Ms. Kinsey. Ruth Stoner Muzine of Friedman and Springwater, also representing Marina Coast Water District.
Thank you. Good afternoon, Ms. Stoner.
Ms. Kinsey, we also have on the line Dr. Kincaid and Ms. Vera Nelson.
Thank you. I appreciate that. And I will turn to City of Marina.
Good afternoon. Skip Spalding of Sharts' Breeze, representing the City of Marina.
Thank you. Good afternoon, Mr. Spalding.
And good afternoon, Larissa Meisenheimer, also of Sharts' Breeze, representing the City of Marina.
Good afternoon, Ms. Meisenheimer. All right, I think we've been around the room, but I will ask, is there anyone else on the line who has not yet had a chance to introduce themselves? I realize there are a few other parties. Please go ahead and speak up. Mr. Newdecker.
Yes, James Newdecker for RMC Pacific Materials.
Thank you very much. I appreciate that. Is there anyone else who I missed? All right, well, I appreciate all of you joining me on relatively short notice. We're here because of the motion from Marina Coast that I received requesting a continuance of phase 3 of the hearing. I also received City of Marina's joinder in that motion. And then earlier today, I received CalAm's response to that motion, at least an initial response to that motion. So I did have a chance to look at all 3 of these documents and read them, although, you know, this is all occurring fairly quickly and I had a few other things on my plate in the last day. So I would appreciate what I'd like to do is just go around the room, start with Marina Coast to just summarize the basis for the motion and go forward from there. I'll hear from Marina Coast, then City of Marina, and then CalAm, and then we can just generally have a discussion. I did want to note, I realized CalAm, you raised some additional evidentiary objections in your filing. What I'd like to do right now is really focus on this question of whether to continue phase 3 of the hearing and get that resolved. And then we can maybe at the end of this conference talk about how to, the most appropriate way to address those additional objections. I just want to sort those out so we don't have them all confused together. I'd like to focus right now on whether and what the topics of what we'd be hearing next week. So with that, I will turn first to Marina Coast and ask you if you just would briefly summarize for me the basis for your motion and your request.
Thank you, Ms. Kinsey. Kyle Brochard for the Marina Coast Water District. As you know, this is phase 3. Phase 2, the experts had a series of meetings to try to come to a consensus on as many issues as possible, and then split apart and made flow models. The groundwater flow models were then each provided to each other in the beginning of June, and phase 2 was about those flow models. Phase 3 is supposed to be about transport models, which relate to the flow models. They go on top, and there are different issues. In their rebuttal for the phase 3 testimony, CalAm has submitted a new groundwater flow model. They've changed the recharge rates, which is an input in the flow model, in their previous flow model, and they've recalibrated, meaning they've changed the hydraulic conductivity values to get a different calibration. It is a new model. This is not the first time that CalAm submitted a new model on rebuttal. A year ago, we were here arguing over a very similar thing when CalAm submitted their 2022 North Marina groundwater model in rebuttal. Mr. Lilly indicated it was not proper for rebuttal, and that's how we ended up with this whole other proceeding. We ended up with phase 2 and phase 3. They've now done it again in phase 3. It's a new model. It's not based on any data that they discovered after phase 2. Mr. Durbin actually identified the issues that they say they're correcting in his testimony when he testified in phase 2. We cited that in our motion. Dr. Ye and Mr. Leffler didn't mention the recharge issue that Mr. Durbin had indicated when they adopted their testimony and when they provided their slides. And we've all moved forward with that understanding that that was the model they were using. And now we have an entirely different model that has entirely different results. And we haven't had a chance to adequately evaluate the model to see what that will do to our opinions, or even to see if it is appropriate for evaluating these things moving forward. So for those reasons, we'd like either to continue the hearing and let us provide rebuttal based on that new model, or to strike any of the testimony based on that new model.
Thank you, Mr. Brochard. Just a couple questions to make sure I understand your position. One is, I think I understood your motion to indicate that your preference in terms of the request was not to strike the evidence because of this. I guess I'll characterize that as a concern, but so I'll say a concern that this recalibrated model would come up later, and so we might as well in a sense, we might as well deal with it now. And within this reference proceeding, I assume the concern is that it might come up later. You know, if I were to submit a report of referee to the court, and then, you know, CalAm may say, well, we have this recalibrated model and it's better, so you should consider this evidence too. This may or may not be your actual concern. You're about to
That's why we're still here. That was the concern a year ago, which is how we ended up in this situation, doing all new models. And yes, that is my concern.
So is it fair to say that your preferred approach to resolving this problem is a continuance of the hearing and not to strike this recalibrated model from the evidentiary record? Or we haven't admitted it yet, but to exclude it from the record?
I don't know that I have a preferred approach.
Okay.
This has gone on for so long, and the court did make some comments at our last status conference that if it continues to drag on, you know, he may just have to move forward with the trial, and I don't think that would be an incredible waste of resources. So I would like to get this moving. However, we need to have an opportunity to evaluate, if it's going to be considered at all, to evaluate it and comment on it, and that will take time.
And I believe you asked for 7 weeks, and I wanted to ask more about the details of the basis for 7 weeks.
We try to figure out the least amount of time that we think we can review the model, and our experts have other commitments that are also coming up in the interim. Most of us have been planning a lot of our work schedules and personal schedules around these hearings over the last year plus, and there are some other issues that just can't be adjusted.
So 7 weeks is in part, I mean, it's not that it would take 7 weeks of concentrated effort to review these differences in the model, but given other commitments that are already in place, that was an estimate of what was reasonable. Is that fair to say?
That's fair to say. Yes, it's hard for us to judge exactly how long it will take to fully evaluate the model without actually getting into it and opening it up. But yes, that's our estimate.
Thank you. I'm sure I'll have more questions, but I think that's all I have for now. I'll go ahead and turn to City of Marina I don't know if you have anything to add. I read your joinder, which was brief, but if you have anything to add, now is the time, please.
Thank you. I'll address it for the City of Marina.
Thank you.
So the city shares MCWD's concerns about what's happened here. To receive an entirely new model on rebuttal, I know it's been characterized as a sensitivity analysis, but it really is more than that. What we've got is something where they've drastically changed the recharge. And in particular, they've focused on changing the recharge in an area that matters a great deal to this project. And the tinkering with can really have an impact on the projected benefits of the project. And so in doing that, they altered the recharge. Then they had to go and alter all of the K values, right? So all of how the water is going to flow through the model. And then they recalibrated it. And there's a whole new set of calibration statistics and information that frankly make it look like this is a worse model, but we haven't had time to digest it yet. And then the implications of this are huge, in that this new model is going to lead to different results on everything from the seawater intrusion fronts, the degradation of groundwater quality, the ocean water percentages of what's taken up in the slant wells, the cross basin flows. And CalAm has indicated that they believe this new model that they put in rebuttal is more favorable to the project and indicates more favorable benefits from the project. And so to have that go in without the city and MCWD having the ability to take a look at it and rebut it, it would just create an incredible amount of prejudice for the city. We want this to be a fair proceeding. I think everyone has put an incredible amount into getting here. And so to have sort of this brand new unrebutted 11th hour model come in and impact the decision without us having had a chance to kick the tires and open it, just seems like it would be sort of an unfair and prejudicial result to the city of Marina. So that's really our concern. And in terms of the remedy, I think there are the two possibilities. One is the extension, and one is striking this information. And on that front, I think Mr. Burchard handled it quite well. I think there's pros and cons to each, but if we really want to address this model, that more time is needed. And then the one last thing I would say is that we've all been in this process for a really long time with like a lot of rounds of hearings. And what we don't want to do is have sort of next week's hearings go forward and then have like a whole nother round of hearings just to talk about the new model. And that's particularly because a lot of what CalAm is introducing in this phase 3 proceeding is based on the new model. And so splitting that wouldn't be very feasible. And so our preference would be, if we're going to do the extension, would be to kick the hearings next week and set them at some time, in the near future. And we think that's really the only way to handle it if there's a continuance. And so with that, if you have any questions for me, I'm happy to address them, but that's all I wanted to present.
Thank you. That's very, very helpful, Ms. Meisenheimer. I appreciate it. I don't have any questions right now, but all of these thoughts, particularly suggestions about potential remedies are welcome here. There's a limited number of possibilities, so we can think about the best one. With that, I will turn to CalAm.
Thank you very much.
Thank you.
Let me start with they say their time issue. They received this model, whether it's a new model or an old model. It's not a new model by any stretch of the imagination. But one thing I think we need to propose is, if you think it's a new model, prove it. They've had this model that they call the new model. We say it's not a new model. And they've had it for 10 days. They're saying now 7 weeks to go through that new model. Their sense of a new model. Our people think, or our experts think, very quickly, it's 1 or 2 days maybe to do that. And they're asking for 7 weeks, which kind of brings me to the point I think this is all about. They want a continuance. They desperately want a continuance. And they know by making these accusations, they have a better chance of getting a continuance. I mean, we've seen it coming. We've seen it before. It happens 2 or 3 different times. There's an accusation made. They haven't gotten something, or they haven't deposed somebody, and now we need a continuance. We don't need a continuance. If they want to take a look at this, that's in front of them. If they can't do it in 2 days, it will surprise us. All our experts says the same thing, and that is that we think maybe a day, maybe more than a day, but not more than a week. It would take them to go through and something they're characterizing now is 7 weeks. It's just not true. It's not, number one, it's not a new model. It's not going to take 7 weeks to get through it. None of that. So we're sitting with a bunch of different, and by the way, I say, as I went back to them, if they believe this, prove it. They could take the model, come back here on Friday tomorrow, and prove it if they can prove it. But what they're doing is they got it 10 days ago, and they're sitting on it. And the reason why they're sitting on it right now is because they know if they made the argument, there'd be a debate, and we would win that debate, I believe. Now, I'm not going to say entirely, but we would win that debate, and they wouldn't get what they wanted. They know by not testing it, they can make whatever claim they want to make against CalAm, and they always do. That seems to be the history of this case. All we want is to move forward. We have a trial date in the Superior Court in 5 months with a judge that's really getting angry about this. One of the times threatened to take the case back. Now, we're not suggesting the case go back. We're not making any representations about any of that. But we have a Superior Court judge, I think a very talented Superior Court judge, is getting tired of this. This case has got to get to the final hearing and move on. I mean, it's been over, 2.5 years right now? And we're still at the point where we're arguing different issues. I think probably should have been, I'm not a water lawyer, so I can't just say water words. But it's been just way too long. And what they're doing now is the people they cooperated with, the people that they cooperated information, they're basically saying they're liars. Our people say, no, it's not a new model. They say you're wrong, it is a new model. Well, I mean, our guys put it together. They're as honest to people as you'll ever find anywhere in the world. I've been at this for 40 years. I would vouch for every single one of them that way. But the simple fact is they want all that forgotten. 10 days ago, if they'd started doing their analysis of this model, we'd be here right now and they'd have the analysis, and they couldn't at that point in time ask for a continuous, because it's all going to be sitting in front of them. I just don't know any other explanation to explain to you why you wouldn't start the analysis as soon as you get it. Apparently, they thought right away that it was a new model. They thought right away that that new model would create some controversy. And now we're in this period of time and they haven't done a thing with it. So, and I also don't know why they think they would be prejudiced. If they don't know what the new model is, and they've got to analyze it, what's it going to do? It's going to be good for us, good for them. We don't know. They don't know. So I don't, that's really all I have to say. Michael, did you want to say anything else?
If I could just briefly follow up, as you may know, Ms. Kinsey, this State Water Board many years ago dealt with many of these exact same issues in favor of county. The Public Utilities Commission then looked at many of these same issues in favor of county. The California Supreme Court refused to review. The California Coastal Commission has reviewed many of these issues in favor of county. They want this project done. As Mr. Moore indicated, we had a CMC, a case management conference before the court, who was irate on how long this has gone. We have a February trial date. This was filed in May, to be specific, May of 2020. So it's actually gone on for over 3 years. The public wants it done. The governor wants it done. In fact, Marina Coast Water District wanted this project done many years ago and filed a case to get it approved, except it got blown up because of an illegal conflict. And in our position, this is the revenge. Having said that, to address specifically, it's not a new model as we put in our papers. What Callan simply did is correct a scientific issue. In that regard, they did a recharge sensitivity run with corrected recharge values using generalized representation of the city. That is not, by definition, a new model. And what hasn't been brought up is this is directly responsive to their direct testimony and allows me to be specific on 2 issues. Number 1, the scenario 3D, 1D, seawater intrusion fund. We look at Marina Coast Water District 165, figure 4.3 on page 28, text section 4.1.3 on page 32, and appendix B figures B17 and B20. This responds to those issues. Secondary issue to which it responds, rebuts, is issues regarding the flow from the Perch Mound dune sand aquifer. And there, if you look at Marina Coast Water District 165, text section 6.3 on page 53, and Marina Exhibit 58, paragraph 56 on page 22, and Marina 59, figures 56A and 56B. Our experts will tell you, and prepare to do so now, that they did the scientific correction to respond to those criticisms. And that has happened throughout this long history, the decade or so history that I've referred. There's always one more issue that Marina points out. Somebody didn't do this, somebody didn't do that. And what we have done, and will probably be doing forever, is we respond to their criticism. And anytime we've responded to their criticism, there's a claim of a new model. And council's reference to say that we did this initially, no. Way back when everybody approved this project, there's some of these issues. Coastal Commission, PUC, Marina continue to take shots at what the model is. So every single time we come back and we address their criticism. So it's not a new model. It's a scientific change that responds to their issues. We can't just sit here with our hands tied behind our back. And I do understand that we're going to address the other issues later, but for them to say that this is a new model, one thing we all know for sure, they have an entirely new expert. So to come in and somehow say that a scientific change is a new model, but at the same time they get an entirely new expert, can't give us underlying data, really seems to strain the credibility of their arguments in this process. So sorry, Mr. Moore, just humbly following up to demonstrate that this will go on forever if we keep allowing this to get exchanged, and the Superior Court will likely yank this withdrawal. We continue this thing. Thank you for your time.
Good job, Mike.
Thank you, Mr. Moore and Mr. Betts. So let me follow up on this, and I know you may have just tried to explain this to me, but I'll ask it again because, I mean, frankly, I don't know that much turns on the rhetoric of whether this is a new model or not a new model. The point I think that is in agreement is that there were some changes to the model, and then the question is how significant are those changes and do they merit additional time for review? One of my questions, I think, which is natural, is to understand the reason for the changes to the model at this point in the proceeding. I think what you just told me, Mr. Betts, was that the reason for the changes were to correct scientific issues, as you called them, in response to criticism raised by Marina Coast and possibly the city of Marina. And that in doing those, making those corrections based on these criticisms, that's how we got to this situation where, as I understand it, there was a change in the amount of groundwater recharge. I think it was, if I remember right, a reduction in the amount of groundwater recharge that was input into the model. Maybe I'll pause there. So far, does this seem to be accurate? Does my understanding seem to be accurate based on your understanding of the situation we're in?
Yes, and to be specific, Mr. Leffler, who's here, can respond, and or any of our experts. But yes, to answer your question, they raised more issues. We made a correction to fix those issues in rebuttal, which is exactly what rebuttal is. But yes, to answer your question, yes. Mr. Leffler, do you wish to further elaborate on that?
Please,
Yes.
Mr. Leffler, if you wouldn't mind, I would appreciate it.
Sure. Yeah. Well, so these are sensitivity runs. Normally anytime you do a model, you often have sensitivity runs where you vary certain parameters and see how that affects model results. And so that's what we've done here, is to do a sensitivity run. And I think it's important to note that, particularly when it comes to a steady state model, recharge and hydraulic conductivity are kind of go hand in hand. So you could either change just one of those, or preferably, when you change one, that has a sort of an adjunct change in the other parameter, so that they're consistent. I would note that the change in the hydraulic conductivity was extremely limited to a small area of layer 2 overlying the FOSVA, and a relatively small change in those values, which actually made those values more consistent with the MCWD model. And so it was a sensitivity run to see how that would affect specific, very narrow issue in scenario D in particular, and the seawater intrusion front associated with scenario D. And because it's really, for the most part, we found that recharge doesn't really impact too many of the final results of all the different scenarios and all the different issues, from ocean water percentage to impacts at MCWD wells. But we noticed that it did have one particular area or issue that it affected, which was seawater intrusion front for scenario D, which is really the only application that we did or showed for that sensitivity run. And then there was that secondary minor issue of the westward flow over the edge of the FOSVA. So it was really, and then finally, it was to make in our local model the recharge consistent with the regional model from Mr. Durbin. Because there was an inconsistency on our part in the original runs, but we're not replacing the original runs. It's just a supplemental run to go with those original runs, which makes it a sensitivity analysis.
Thank you, Mr. Leffler. I think we may very well have more questions for you, but I think for now, what I'd like to do is turn back to you, Mr. Brochard, if you have any responses. One, just to put this forward, of course, I am very concerned about the length of time that has, what's passed is past is one thing, but really it's meeting the court's trial. If the court has a trial date set for February and we need a report of referee by then, we're really up against the end of time. So that's an element. On the other hand, of course, we want to get this right. So that's one question that I just so you know that I have in my brain that I'm dealing with. One issue here is if there was a continuance, I really do think that that may require you going to the court and saying, dear judge, we can't make a February trial date. And I don't know that you're prepared to do that, but I want to give you a chance to at least, I'm not sure that that's where I'm going, but I wanted to give you a chance to respond not only to the characterization of the changes in the model, and then also if you have any thoughts about what should be done here given the limitations on time. That would be.
We have a case management conference in the Superior Court, I believe in October. We had advised the court last time that we didn't think the current trial date was workable. I don't think there's any chance that the State Water Board, can have a report done. There's a, as you know, there's a procedure of reviews and comments and stuff before you can adopt a report. To have that done in enough time before trial to go to trial, I think is unlikely at this point. So we're going to have to tell the court that in October regardless. And I think we'll be looking hopefully to tell him that this proceeding will be done on a date certain and that we expect a finalized report on a date certain, and that he can set a trial knowing that it's going to go forward at some point in 2024, further out in 2024. As for the time issue, again, Mr. Durbin identified the problem that they changed in the phase 2 testimony, in his phase 2 proceedings. On July 17th, he said he'd known about it within that month. He said he had talked to Dr. Ye about it, that Dr. Ye was working on it. This is not something that they did in 2 days and that we can review in 2 days. They've been working on it for over 6 months, for over 6 weeks to make these changes, to figure out what it said, to see if they wanted to use it. So that's where we are. And we need an equal amount of time at the very least to look and see what they've done and address the testimony that they have provided about it. They're saying it's in rebuttal, but the report that they provided that describes this, this model doesn't mention that it's rebutting anything. And I forget exactly what, I think it's CalAm 187. And it starts on page 206. They start talking about this new model that they're using. They don't say that they're rebutting anything. They say they're doing it to change the recharge, to make it consistent with Mr. Durbin's model, which is an issue they knew about. So this isn't rebutting anything from phase 3. Marina Coast Water District did not criticize in their phase 3 testimony the amount of recharge that was put on the dune sand, the DSA. It's simply not rebutting anything that Marina Coast criticized in these phase 3 testimony. It's an attempt to go back and redo what they did in phase 2. And we need a chance to review it to see exactly what effect it has and whether it's reasonable or not.
And then Mr. Brochard, I think Ms. Meisenheimer actually addressed this, but I'm going to ask the same question of you, Mr. Brochard, and then I'll turn to you, Ms. Meisenheimer. I want a better understanding. Frankly, my inclination here would be to, and I see your hand too, Mr. Wilkins, so thank you, would be to go forward with the hearings next week and then consider whether to schedule some kind of rebuttal. And I know Ms. Meisenheimer indicated that she didn't think this was appropriate because of the central importance, if it's fair to say, central importance of these model runs to the evidence that would be presented in phase 3. And I just wanted to see if you had any additional response, Mr. Brochard, about whether you think it would be appropriate to continue with the hearing and then schedule rebuttal, or what your concerns would be with that approach.
I completely agree with Ms. Meisenheimer on that. I think that's the worst case scenario, is trying to split up the proceedings like that. We would ask for a continuance to allow Marina Coast and the city of Marina to provide rebuttal based on this new model, and that's it. That's what we did the last time, and then go forward with the hearings after that. That's what we did the last time that CalAm submitted a new model on rebuttal, and that's what we'd asked to do again.
But why, right? You haven't answered. Why does it not? What is the concern about? I mean, you call it splitting the hearings, but in some ways it's just. And there may be a good reason. I'm just trying to wrap my mind around why
the
that
models
would be inefficient.
The models are all interrelated, and all of the topics that we're talking about are interrelated. The transport models go on top of the flow models. So if you change aspects of the flow models, it will change the results you get in the transport models. So we can't really go forward with hearings next week about the transport models if we haven't had a time to fully analyze one of the flow models that they're using for it.
Okay. So the changes here, and I'm coming into this fairly new, the changes here that we're talking about affect the underlying flow models, not
Yeah,
just
they made changes to the flow models, and then the transport model kind of sits on top of the flow model.
Yeah.
So the inputs they go through all of it.
What I'd like to turn to you, Ms. Meisenheimer. I think my team had another question for Mr. Leffler as well. So maybe Ms. Meisenheimer, I'll turn to you. I might let my team ask the more technical question of Mr. Leffler, and then Mr. Wilkins, I see your hand here as well. Or maybe we'll hear between the two of you, whoever wants to go first is fine with me. You represent the same party. So however you'd like to do that, I will turn.
I'm with Marina Coast Water District.
You are. Thank
Ms.
you.
Meisenheimer's with the city. So just for the record.
Thank you. Mr. Wilkins, why don't you go first, because we just heard from Marina Coast Water District, Mr. Wilkins, then Ms. Meisenheimer, and then I'll let my team ask Mr. Leffler more about the nature of these changes to the model. So Mr. Wilkins, please go ahead.
So I just want to make it clear that the testimony that refers to this new model says it is a correction to their prior flow model. And so what they imply, at least with the testimony, is that the prior flow model was wrong and used the wrong recharge. And this does affect multiple analyses that we have put forward in our direct and rebuttal testimonies. And we have to redo those analyses. I think it's important, since you've heard from Mr. Leffler, for Dr. Kincaid is here, and he can explain why this is not a sensitivity analysis, at least as it's been explained to us. When you change the parameters, you change the recharge and you recalibrate, that is a new model. That is not a sensitivity run. But I'm not the expert, and I was hoping that you would hear from Dr. Kincaid on this topic before you made any decision.
Good. Thank you, Mr. Wilkins. I appreciate that. We will hear from Dr. Kincaid as well after we hear from Mr. Leffler. So, but Ms. Meisenheimer, do you have something to add at this point?
Sure. Just to provide a little bit of context, I know that there's a lot of concern about the pending court case and that we have to be very mindful of it. And I think every person in this proceeding would like to get it wrapped up soon. It's been a long process. However, in that court hearing, the court wasn't irate. It wasn't, there wasn't extreme anger. I think the court had some concerns and is hoping that this will get wrapped up soon. But that's why the court set a status conference, and I believe it's on November 9th, to sort of see where we were in progress with the State Water Board report, and then make a decision about what to do with that trial date. So again, I think that there is urgency and a desire to wrap up, but that's the circumstance there. And then I just wanted to echo, I think Mr. Burchard did an extremely good job explaining it, but in this phase 3, and if you look at these phase 3 slides, the slide decks, they're very kind of the conclusions at the end of this process, right? So you have all of these sort of conclusions about, is there seawater intrusion? What is the ocean water percentage uptake going to be? These really important issues that are going to be before the AHO. And a lot of them in this phase 3 proceeding, what CalAM is doing is relying on this new groundwater flow model. And so it would be very difficult to try to have this phase 3 hearing where the conclusions are all based on the model, but then have a separate proceeding on the model later. I mean, I think from my perspective, having a shorter continuance, but having all of the issues addressed at the same time may make more sense. But I think that's really problematic and fairly unworkable to try to have a split hearing when a lot of what's in phase 3 is based on the very thing we're slicing and separating.
Thank you. I appreciate that as well. I think the question from my team for Mr. Leffler, and then I'll ask Mr. Kincaid, Dr. Kincaid to chime in as well, gets to this question of whether or not it's appropriate to characterize this as a sensitivity analysis. But I think because the question is better phrased in technical terms, so that's the overall question. But I think I'm going to turn to my team, Ms. Graziano or Mr. Woldridge, if you can ask that in the appropriate language to get the answer that we're looking for very specifically of Mr. Leffler, I'd appreciate that.
Yes. So, there's two sides to this story. I'm hearing maybe it was a sensitivity analysis that was conducted, and then I'm hearing there's a completely different model that was done where the recharge and hydraulic connectivity were changed, and that was carried through to phase 3. So Mr. Leffler, Dr. Ye, can you please explain what the changes were and where they carry through to the phase 3 in the transport model?
Sure. Yeah, I'll start, and Dr. Ye can add if he likes. So the changes that were made were to the recharge in the basically south of the river in the dune sand complex area, and so there was a change in the amount of volume of recharge and its how that was distributed. And then there was just in model layer 2, which is the perch mounted aquifer, the dune sand aquifer, and just in the area over the FOSVA, there was a slight change in hydraulic conductivity values that had previously ranged from, I think, about 8 to around 50 feet per day to now 8 feet to about, I think, 17 to 20 feet per day. So there was just a small decrease in hydraulic conductivity values. So those were the changes that were made that were, sort of a sensitivity run on those parameters compared to what was in the original model. And then that was carried through only to look at the seawater intrusion front for scenario D, 3D versus 1D. And that was the primary use of that or results from that sensitivity run. And then there was also a characterization of the flow from that small perch mounted aquifer across the western edge of the FOSVA. And those were supplemental to the original run. So we're not replacing the original runs for those two narrow issues. We're just presenting, if you have those parameters, the way we've stated and documented there in Appendix G, that's you get the result that we show. And I want to make clear that this has nothing to do with ocean water percentage. We didn't do anything with ocean water percentage with this. We didn't change anything or look at TDS in the existing MCWD wells. We did not look at seawater intrusion front for the other scenarios. So these items that they're saying are all changed have not changed. Those are the same as they've always been. And for those two narrow issues of scenario D and the flow across the western edge of the FOSVA, we have provided a sensitivity range for those two narrow issues with this additional updated sensitivity analysis. So it's a very narrow sensitivity range that we're presenting. We're not replacing results. So that's why it's a sensitivity run. It's providing a range of the results for those two narrow issues with the two different recharge amounts.
Thank you, Mr. Leffler. Ms. Graziano, did you have any follow-up to ask based on that?
No, I don't have follow-up. Thank you.
And I'll turn.
To step on it, I don't know if Dr. Ye, did you have any follow-up? And I apologize to anyone or everyone if I step on this. I didn't know if Dr. Ye, you wanted to follow up.
Yes, yeah. I just want to add the recharge rate we change. It's provided in our Appendix G, figure G1, showing the land use and unit water rates applied to that zone, recharge zone. Then we also modify the horizontal hydraulic conductivity for model layer 2. That's the upper dune sand aquifer. You can see the side-by-side comparison. The K value we change. It's just like probably like a few zone. We showing the number of changes. We didn't change the zone boundaries.
Thank you, Dr. Ye. I'll turn now. I'd like turn to you, Dr. Kincaid. I don't have I'm not going to specifically direct you on the, I mean, you heard the question that was just posed to Mr. Leffler and Dr. Ye. But feel free to expound on this. What would you like to tell us about your assessment of whether this is truly a sensitivity analysis or what impacts? I know you haven't had a chance to crack into the model. That's the whole point here, but any comments you may have about these changes would be helpful.
Yes, thank you. Yeah, our concern is explicitly that it is a new model because they recalibrated. So when it was described as a sensitivity run, which is completely, that's the standard practice as has been described. That's one thing, but the way it was presented in the final document was as a corrected version of the model. In other words, to be perceived as the correct version from which interpretation should be derived. So that is fundamentally our concern, is that it made that change. So we saw the recharge sensitivity component of it, and then incorporated our comments on that as part of our rebuttal testimony. But then the documents that we received indicated that no, in fact, it was a new recalibrated and quote unquote corrected version of the model. And so that really creates our concern. The second thing I want to point out is that we did not receive the model files 10 days ago. We received the model files after the rebuttal testimonies we were made aware of their availability after the rebuttal testimonies were submitted late on Wednesday. We had to download 50 gigabytes of data because the files were embedded into the same zip file, which took, on my part, it took until the middle of the day on Thursday to get the files. And then I had to transfer them to my modeling staff, which took another half a day or more. So we weren't able to actually open the models and look at anything until Friday, the day before a holiday weekend, where a lot of my staff my team was gone and unavailable. And so this really boils down to just a couple of days of being able to really look at anything. And by the way, we weren't, just sitting around doing nothing during that time period. We were preparing for what we thought was going to be the hearing in other ways. So it's the fact that it's classified or has been described as a quote corrected version of the model. It was recalibrated. That, as I said in my declaration, as I understood our order from Mr. Lilly, I interpreted as a pencils down was in June for the calibration component of the model, so that then afterward we would not find ourselves in this exact scenario in which you're going to be challenged to look at what the idea was to have our interpretation of the model, their interpretation of the model, and all the scenarios after that. Now, our fear is that you're going to be confronted with one that CalAm considers to be correct, and therefore you should give favor to, as opposed to the one that we've done all of our comparisons against. And then the last thing I'd like to say is that this entire assessment of impact boils down to changes to what happens in that minor area that has been described to you. So the amount of flow that comes from the dune sand aquifer and infiltrates vertically into the upper 180-foot aquifer is 100% of what constitutes is the process that results in impact. So everything is driven by that amount of flow. So these two things that they're responding to is in my final concern or criticism is that we do point things out with respect to the model, and we have consistently pointed things out with respect to the model. And in some cases, in prior years, we were looking specifically at model issues like how well the model is calibrated and if it was a good or should be a reliable or not reliable predictor. But in these particular cases, we're using the model to try to understand what's happening in the real world. And the concerns that are pointed out here are not flaws in the model. They're interpretations of what's happening in the real world. How much water, what do both models say about how much water is coming from the dune sand aquifer, flowing into the upper 180, which is therefore responsible for the freshwater conditions in the upper 180, the higher than sea level heads in the upper 180-foot aquifer, and then consequently driving the ocean water percentage, and the corollary of which is how much water is coming from inland sources. The amount of induced seawater intrusion that takes place inside and outside of the capture zone. All of those things are affected by the amount of flow that comes in across that boundary. So yes, we pointed those things out in our testimony. And then this was a change in the model designed to affect the simulation of those processes. So this is not correcting a model inadequacy. It's a change to the model designed to affect a change in the prediction. So those are our primary concerns.
Thank you, Dr. Kincaid. Appreciate it. I think at some point, what I'd like to do is I would like to take a brief break and confer with my team on some of these issues, but I think I owe Cal-Am another chance to speak up. I've heard a fair amount from Marina Coast and City of Marina. So I would look back to see, I don't know, Mr. Moore or Mr. Betts, if you have anything that you would like to follow up on for me to consider before I take a brief. I don't want this to go on. I know you all have other things to do this afternoon. This was quite a late notice meeting, but is there anything you'd like to add before I take a brief break and confer?
I'd like to find out if Pete would like another session. Pete, are you there? I don't see you up there.
I see Mr. Leffler. He's on my screen.
Yeah.
He's on your screen.
Yeah.
Okay. Would you like to address what the doctor just testified to?
I think I would just like to reemphasize that we're not replacing any runs that we've done as part of phase 2 and phase 3. These are supplementary to a very narrow couple of issues, and their sensitivity on the original analyses we provided on those 2 issues to show the difference in 2 amounts of recharge on the result of those 2 issues. Again, scenario D, 3D, seawater intrusion front versus 1D, and the flow across the FO-SVA edge boundary. So it's not a new model presenting all new results. It's supplementary to provide, sensitivity of the range for just those 2 very narrow issues.
Thank you, Mr. Leffler. Mr. Moore or Mr. Betts, is there anything else you'd like to add?
I just would go. I'm sorry, Mr. Moore.
No, go ahead. Go ahead, Michael.
Just the overall point that we started with. If this is just to go on and on and on. And regarding the trial date, we should actually be advised there was a prior trial that got vacated because of further delays. We're on our 2nd trial date at this point. And there's motions that need to be filed and the like, but whether it's this proceeding, the coastal commission, City of Marina, delay it and delay it, delay it. It has to get done at some point in time. And nothing that we've heard suggests that this proceeding can't go next week with the information and all the work that's been done for us. There's a small issue there. Whether it's a new model or a scientific change, that it does not affect everything. We proceed as planned next week to keep this process going.
May I say one more thing? And reflecting on the Superior Court judge, there was a time not too long ago where we were in a hearing, yes, and he said, look, if you guys can't get it done or they can't get it done, I'll take it over myself. So I don't think that's somebody who's being cooperative with the sides. I think somebody who was getting very frustrated and is willing to take over the case by himself without our input. So we want our input and your input to make any difference in the ultimate decision. We've got to get this moving.
Thank you, Mr. Moore. And I'm going to turn back to Mr. Brochard or Mr. Wilkins one more time, I asked this question before and maybe it's not sinking in, but I'm just thinking this through. if we have the rebuttal testimony in and the request here is really is to submit Sir rebuttal, I understand that the changes to the flow model affect a lot of things, but as I understand it, your request is not to withdraw your rebuttal testimony and then resubmit. I mean, this is all coming in on rebuttal, so there's no change to your rebuttal. There wouldn't be change to your rebuttal testimony based on further analysis of this change in the model, because that's not the order. I mean, all of the rebuttal evidence was submitted at one time. So I think I'm still not understanding why we can't proceed at least partially next week with some of the days and move forward with what we have in terms of rebuttal evidence, and then address if there are other issues to be addressed and a need for additional time later in Sir rebuttal. And I understand, I have heard very clearly that you think this is a terrible idea, and I just want to give you another chance to explain to me why it's a terrible idea.
Our initial testimony was based on our interpretation, our models. Then the rebuttal testimony was responding to their initial testimony, which was their 2023 flow model and the solute transport model that went with that. In their rebuttal, it's a different flow model. They've now come up with a different flow model, which, as you heard Dr. Kincaid say, they change the areas that are most impactful for the analyses that we're doing in this proceeding, the things we care about the most, the whole point of this. And then those are going to have impacts on the transport issues as well. So their rebuttal is essentially, their quote unquote rebuttal testimony is essentially changing, and it's entirely new and supplemental to their initial testimony. And we haven't had a chance to address it. And we think we need to. I can just, well, I would like to just read, when this issue came up in July, when Mr. Durbin was questioned on cross-examination about the fact that he had acknowledged and he had saw this recharge issue, and he talked about it with Cal-Am, and Ms. Meisenheimer asked him why it didn't address it, why it wasn't fixed, and he said, the issue came up after the calibrated models were exchanged, so it wasn't possible to change it. And then for some reason, they did change it in their reply to phase 3, 2 months later. And it would be, I agree with Ms. Meisenheimer that it would be incredibly prejudicial for us to go forward somehow providing testimony addressing one part of their model and then a different model later on when their opinions and their analysis and their conclusions include or need to include consideration of all of the evidence and all of the models.
So I think, and I may be misunderstanding, I mean, it sounds like what you're telling me is that as in fact, because as in the way you're characterizing it and describing it, these model runs are coming in sort of late in the, maybe not sort of late, but are coming in late in the phasing of this process. That essentially what this effectively does is change potentially your experts would otherwise be their phase 3 testimony in its entirety, potentially. Depending on
it may or may not. Part of the problem is we haven't had a chance to evaluate it.
So in effect, it may be that the testimony that you've already submitted is if the changes in this model come in and that expert testimony comes in and those model runs come in, that effectively your expert's phase 3 testimony may be different. So what we have is may or may not be particularly helpful. It would make more sense to look at it all together in one package.
Yeah, our testimony is phase 3 direct and rebuttal testimony is addressed to the models that we thought we were going to be testifying about. And I mean, our analysis regarding those models, that part's not going to change, but it would be confusing to then do our analysis to another model. And when is it going to stop?
Okay.
Sorry, can I briefly respond?
Just one, you will get a chance to respond, Mr. Betts. I want to turn to Ms. Meisenheimer or Mr. Wilkins. If you, either of you had, Mr. Wilkins, you can go first if you have anything you want to add to that.
I would just add that I think the concern is our experts, when they provide their conclusions for phase 3, and similarly when we are trying to cross-examine CalAM's experts as to their conclusions on phase 3. We won't know how this new model affects our experts' opinions ultimately. Obviously, we believe that it's what we are likely to conclude is that this actually makes the prior version of the prior calibration worse. That we've seen, that's the only thing we've seen, as you've seen from Dr. Kincaid's declaration. But we need to unwrap that before we cross-examine CalAM's experts, and our experts need to consider that when they're drawing their ultimate conclusions for phase 3. So could it alter them? It probably supplements them more than alters them, but it's possible to alter them. And so that's why we believe it's prudent to do it all at one time.
Thank you, Mr. Wilkins. Yeah, I'm just trying to think this through. I mean, in theory, it's really the cross-examination, because the direct testimony of your experts will be with respect to your own model. However, your cross-examination of CalAM's experts would, of course, be with respect to but on their direct testimony, they didn't submit these model runs on direct testimony, right? So why? Help me understand why the cross-examination of their direct testimony in phase 3 is affected by these changes in the model.
Mr. Lilly, or previously in these proceedings, we have dealt with direct and rebuttal testimony at the same time with each expert panel. So we haven't distinguished between them just for time and efficiency purposes. So that's the way it's been handled. So when I say, our experts' testimony, they will be providing both their direct and a rebuttal testimony at the same time. Our slides are set up that way currently to provide both their direct and rebuttal testimony in their slides. We envision that would be the way it would be handled. Obviously, that was one of the things we're going to have questions for you today, is how long our experts were going to have and how this was potentially going to be managed, if it would be like all the prior hearings or not. But the answer is, we haven't distinguished between direct and rebuttal testimony thus far in the proceedings.
Okay. Thank you. That's helpful background here. Mr. Betts, I have not forgotten about you, but I'm going to work around the room and we will come back to you. Ms. Meisenheimer, please go ahead.
Thank you. In terms of your question about the challenge of doing right now the examinations on their direct, one thing I want to highlight, and this is from CalAM's Exhibit 187, page 46. And in that, they explained that the CalAM recharge analysis, this new model, and forgive me because it's a little technical, but they say, they describe how they did their initial model. And then they say, however, this was incorrect since unit rates were only applied to a portion of the land use area within the SVSM. And they just then describe all the different problems that come from that. They say, upon further discussion with Mr. Durbin regarding the process, and then they describe how they've done a new model to correct the problems in their initial model. And so to have a phase now where we do it based on their direct, which they contend those models are now not correct, but we haven't had a chance to analyze why they say they're incorrect and really develop questions based on that. I think it would be problematic. And again, just much easier to do all of the examinations together in one set of hearings.
Thank you. Thank you, Ms. Meisenheimer. At this point, I think I will go ahead and turn to you, Mr. Betts. I'll start with you, but also Mr. Moore, if you want to join in, please go ahead.
First, I understand there may be an issue with my speaker, for which I apologize. But two brief points. Number one, what I just heard over the last 10, 15 minutes is they're not sure one way or another whether this will affect anything. So to derail what we've been doing for over a year with the trial date coming up in February seems to make absolutely no sense. And that's been highlighted by what they just said over the last 10 minutes. No one knows if it's going to change. My second issue is this is just an issue for the sensitivity runs. We stand behind all the prior runs supporting our testimony, going back for how long? So We're just talking about a very small issue, which again doesn't seem to be justification for undoing something or a schedule that we've had for something that hypothetically could change. That's what I wish to add. Thank you.
Thank you, Mr. Betts. And I see, Mr. Leffler, you have a hand and you are welcome to chime in at this point.
Yeah, just a quick, comment on Ms. Meisenheimer characterized what was in the report as saying the models were incorrect. We were talking about the recharge, and that this was an adjustment to the recharge. And in fact, the original recharge we have in our models is actually quite similar to what MCWD has in their models. But we've always been saying how that's overestimated. And so this is again, a recharge sensitivity run with a lower amount of recharge that is, more correct and consistent with Mr. Durbin's regional model. And so it's not that the original models are incorrect or the way they've been characterized here. Again, these are supplementary to show you what is the difference in a model run for the very narrow issue of scenario D with an overestimated amount of recharge that both original models have, and this adjustment to a more correct recharge in the sensitivity run. And it appears again that recharge doesn't really affect much of the model results except for this very narrow issue. So I want to just, make sure it's understood. We're not characterizing our original models as incorrect. We're making a sensitivity run on the recharge in those models.
Thank you, Mr. Leffler. All right, it is 2:08. What I'd like to do is take, I'm going to give myself 15 minutes. So we can have a short break, and I'm going to confer with my team, but I would like to reconvene. If we can take 15 minutes and reconvene so that we can try to get some resolution here so we all know what we're doing next week. It's Thursday, so it would be good to know, or at least have some direction. So if it's 2:09, let's go ahead and reconvene at 2:24 here on the same Zoom. We'll leave the line open, and then we can I'll give some direction as to how we should proceed. But thank you for all of your input, and I will see you in 15 minutes.
Kyle, can you hear me?
I can hear you.
We're on the Zoom. Everybody can hear you, Todd.
All right, it is 2:24, so I'd like to get started so that we don't keep you here any longer than is necessary. I did have a chance to confer with my team and have some additional thoughts. So I wanted to put out this, what I would like to do, and then we can talk about scheduling. I realize scheduling may actually affect what we end up deciding to do here, because there are a lot of parties and a lot of experts, and trying to get us together is a challenge, I realize. So what I'm inclined to do here is go forward next week with the phase 3 direct testimony and cross-examination on that direct testimony. I realize that may take some sorting out for you, since that hasn't been what we've done in the past in this proceeding, that the direct and the rebuttal were put on together. But in this case, I think it makes sense to separate those out so that we can continue to move forward and at least get part of this done on schedule. So that's my initial thought. Again, because I realize that may take some sorting out, and you may actually need to change your slide presentations to accommodate that. What I was initially thinking is that we'd cancel and I think we wouldn't need as much time because we're not going to have rebuttal. What I was thinking of doing is canceling Monday and possibly also Tuesday of next week in terms of hearings, and we would start Wednesday and go through as needed to get through the direct testimony. And with that, what I was thinking was that we would have those revised slide decks due Monday afternoon. So you would have a little time to sort through those and then get those into our office. So I'm going to ask for your comments on all of this, but I wanted to put that out there as to what I'm thinking. And then we would look down the road. I'm concerned about, I realize that Dr. Kincaid, I think, is traveling out of the country and there may be other conflicts. So I want to look at when we may be able to schedule additional hearing days, which I envision would cover both the rebuttal, phase 3 rebuttal testimony, and then also SIR rebuttal. I intend to allow for SIR rebuttal here, but that we could put those on together. I am not inclined to stretch that out 7 weeks. I'd rather do it in the next 5 weeks, if possible. If we can, I was initially looking out on the calendar approximately October 6th as a deadline for SIR rebuttal evidence, and then possibly convening hearing days. And I realize we all need to talk about whether these are even available. Let me pull up my calendar, excuse me. I was looking at possible hearing days in October, October 16th, 17th, and then the morning of the 18th. That may or may not be possible, and you're going to tell me if it is. But I do have concerns if we start stretching way out. I may actually revise what I'm thinking about what we would do here. Obviously, if we go in this route, I think we would need to revise other deadlines having to do with the draft report submittal, which I think is October 16th right now. We can talk about that if we figure this out. But that's the direction I'm leaning. That said, if we need to schedule this way out, I may want to come up with another plan, because I don't want this to stretch on for too long. But I realize there are other commitments in your life, which is appropriate. So with that proposal on the table, which is, let me just summarize it again, that we would start with direct testimony next week, either Tuesday or Wednesday. Then we would have SIR rebuttal due around October 6th. I believe that's about 3 weeks out from the direct testimony. And then scheduling hearing days possibly the week of the 16th. But we'll see how that works. So I will go to the room. I think we'll start with, I suppose I'll go in the same order. We'll start with Marina Coast, Mr. Burchard, or, but we'll start with you. Do you care to comment on that proposal or conflicts to it, or what are your thoughts?
Yes, thank you, Ms. Kinsey. I think that proposal would not be our preference, and I think it'd be very, I think it would be difficult and inefficient. I think a lot of the questions on direct testimony would be, well, did you consider this? Did you look at this? Have you responded to these comments? Would just lead into kind of the rebuttal, those things that are in the rebuttal, which then you would want to address. So I'm not sure how that would work or how efficient that would be. As for whether we could provide rebuttal testimony by 10/6, I think that would be very difficult. We have members of our team who are on vacation and not going to be around. That's why we had said the 7 weeks. That's why we'd requested the 7 weeks for the SIR rebuttal.
Can you just do math for me? Maybe you don't have it in your head. What is 7 weeks out? roughly?
7 weeks out from today would be, I think, October 19th.
Okay, that's helpful. Thank you. That target is helpful.
I'm sorry, October 26th. I can't count.
We're lawyers.
Yes.
I'm certainly going to turn to Cal-Am, but let me hear let me go around the room here.
Ms. Kinsey, I think what we're going to say.
You're
will
just going to
probably
blow up the whole thing. Good. Okay, Mr.
No,
Moore,
no,
go
no,
ahead.
no, we're not. I think what's going to happen is that we'll end our discussion. And what I have to say
Right.
is that we are deeply concerned about the fact that that Superior Court case is not going to go forward. It's going to be, it may cause some real repercussions. So we'll withdraw all the documents that they want us to withdraw, or they want you to take out, and we'll withdraw them all. We can go forward without that and without that issue. So I want to just save you one more person to talk to around the room.
Okay, so let me make sure I understand your proposal, and this may require you, now I'm wondering if the parties should meet and confer for a bit, and then we reconvene, whether it's today or tomorrow. But let's dig into this to make sure I understand. The offer is to withdraw the portions of rebuttal testimony submitted by Cal-Am that includes these changes to the model with respect to groundwater recharge and other associated changes. Is that an accurate summary?
That is accurate. Michael, is that the way you understand it?
It is, assuming we go ahead next week and we get this thing done.
That's right. Right.
Right. Understood. Okay. So, Mr. Brochard, I realize this may be very short notice unless you all conferred during the break, which it sounds like you may have not have. Do you have any comments on this proposal? And you'd like to think about it as a fair comment, if that's.
I would, but it just immediately raises a pretty large concern. As you noted when we first started this, that the concern is that we're going to go through all of this. The board is going to issue an opinion, and then if Cal-Am doesn't like the opinion that the board issues, we're then going to go to trial, and they're going to say, we have this new model. We were going to propose it, but because of timing issues, we were forced to withdraw it. This is what the court should be looking at, and we should be able to put forth additional evidence about this new model. I would imagine that that's what's going to happen. So I don't know if it really solves our problem.
But we're withdrawing it, and this goes to my underlying comments that I made. There's always an effort to delay, no matter what. Their relief that we're here for is either to continue or to strike it. That's what they asked you to do an hour ago. We're agreeing, we'll strike it. And now they still won't agree to it, which goes to my overall point that whether it's the Water Board, the PUC, the Coastal Commission, the Supreme Court, they will never proceed with this matter.
Well,
so that just makes no sense. We have a record here. We were willing to strike it. We're granting them the relief. Let's go.
Is the offer to strike it and then an agreement not to attempt to use it again in this litigation? Is that what the offer is?
Look, let me say something. Michael and I have tried a lot of cases. I've probably tried 85 cases. We're making a representation right now as attorneys licensed in California that we want to withdraw that. And part of that obviously is we're not going to use it again. I mean, I know the rules. I've had this for 40 years. We know what the rules are when you withdraw something. I don't know what this petty conversation is all about. We withdrew it. We're withdrawing it. Nothing more to be discussed.
Thank you, Mr. Moore. Thank you. That's enough. Thank you, Mr. Moore. Thank you, Mr. Betts and Mr. Burchard. It sounds so thank you. I mean, honestly, thank you for considering this and moving forward on this. Here's what I'd like to do. I think this is an appropriate issue for you to meet and confer on. It sounds like there's room for progress, and that maybe you can get something in writing that goes to the comfort. And I encourage you to work on this, the comfort of all parties. I don't want to take more of your time than I need to. Obviously, we want to get this all pinned down before the hearing starts next week. But I think the thing to do is to give you the chance to discuss, and then we reconvene if your schedules will allow. We'll see if there's just absolute conflicts, but if we can reconvene at 9 a.m. tomorrow morning, once you've had a chance to talk to each other. I realize it's short notice, but let's reconvene at 9 a.m. See if you're able to come to an agreement that's adequate, whether that agreement is a oral so-called gentleman's agreement, or whether even better, you can transmit it in writing. I think then we have it in the record and then everyone understands it. and we can proceed with the hearing with the evidence, without the evidence, the following week, that makes a lot of sense to me. So what I'm inclined to do at this point is schedule for 9 a.m. tomorrow morning for us to reconvene and pick up this conversation. And I'd be directing Marina Coast, City of Marina, and CalAm to confer maybe immediately after this conference, but when you can, this afternoon or early tomorrow morning, and see if you can come up with a solution.
Can I ask a question?
Mr. Moore, yes.
Don't we have a right to just dismiss clause of action? We don't need their okay on it. We're dismissing part of the case, part of the evidence. There's no, I don't need to get for shards. Okay, geez, it's nice to have you. No, we can do that, I think, without any, I mean, I'm not even sure you have the authority to stop me from dismissing part of the case.
Mr. Moore, I think I agree with you in the sense that I can't require you to put on any, well, I don't know. Maybe
It'd be hard.
This is a little bit of a different proceeding, but maybe let's not get into that. But yes, I think I generally agree with you that if you choose to withdraw certain of your evidence and not put on testimony from your experts on certain elements, that's entirely up to you. What I'm asking all the three parties to do is to see if you can come to an agreement and a mutual understanding. If you can't, then we'll deal with it in the morning, and I'll decide where to go from there. Mr. Wilkins, I see you have a hand. Please go ahead.
So I assume we'll be able to come up with a solution for this. I think one of the logistics for next week, assuming we go forward, would it be similar to the way the prior hearings have been conducted, where CalAm would present its witnesses first? Obviously, the reason I ask this is because I assume that in terms of withdrawing this testimony, they would submit new slides that no longer included that testimony, as well as new evidence. And I just want to know when you would want to have that so we could actually start. And we could actually, again, I think most of the work would be on CalAm's side in terms of revising things. We'll obviously have that discussion. And so I just want to know how you would envision the hearing going. And if that is what you would envision them doing, is submitting new slides and new evidence withdrawing this testimony, or whether it would just be simply some other type of, I guess I'm looking for what you would like to see happen in terms of order and preference for how they would withdraw a testimony.
I mean, the answer is partially, I don't know, which is why I would give us until 9 o'clock tomorrow morning to figure that out. But yes, I think in terms of ordering, it makes sense to continue, and you can inform me on how this worked before, but it makes sense to continue in the manner in which you've done so far in this proceeding, that CalAm would present first. It sounds like the way this has been done is that direct and rebuttal were essentially put on at the same time, and cross-examination covered both. So if there were changes to the rebuttal testimony, that would need to be reflected in the slides, and then also amended versions of that testimony and withdrawal of some or all of the exhibits. I'm not sure how many of the exhibits that would affect. So I can understand there may be, I mean, even if there's a mutual understanding on a general level, there may be some issues to work out in terms of the specifics as to what testimony is excluded and what is not. I'm not sure. So I would consider, if we needed another day, if we wanted to start the hearing on Tuesday, because we needed to do that to give a little more time, we could do that. But that's something that I would want to address in the morning once I understand the scope of the agreement. Does that make sense, Mr. Wilkins? You moved on my screen. Now I found you.
Sorry. Yes, no, that makes sense. So we can discuss it. I just wanted to make sure I understood how you wanted to proceed next week. Thank you.
Okay, thank you.
I do have, I apologize, one other issue that I respectfully believe you said we could reserve to the end, and I hope my microphone's better, and that is striking the undisclosed expert. And there's no dispute here whether that's new or not. As we briefed in our papers, whether it's the California Code of Regulations, the Code of Civil Procedure, Common Fairness, we have an entirely new expert here. We were supposed to disclose experts in May of 2022. Mr. Lilly was very strict about that. He gave us guidelines. We were able to do depositions, gather documents, what went into the reports. And here at phase 3 in rebuttal, we have an entirely new expert that wants to opine about something that the courts have already rejected, as we pointed out. But putting aside the substance, that truly is entirely unfair. There's no question whether it's a new report or a new rebuttal or a new model. He's entirely new. And I think it's very important to address that now, to strike his testimony for all the fairness reasons, particularly in light of what we just heard from the other side of concerns about an amendment to a model.
So thank you, Mr. Betts. I think it is fair to raise those issues now. What I'm intending to do, I mean, as you can understand, part of my response to that, these objections may have been affected by how we were going to schedule the hearing. I mean, if there was going to be some rebuttal, that would potentially affect my thinking about whether certain evidence is in or out. Just a general reminder, I think it's been the case in this proceeding, but it's certainly true in other proceedings that I've run. In general, most evidence comes in. These are the standards here are relaxed. However, I understand you've made these points and I would consider them. What I'm thinking would make sense if we are starting the hearing on Monday or Tuesday morning. What I'd like to do is give Marina Coast and the city of Marina a chance to respond in writing, probably by the end of the day tomorrow, so that I can consider those arguments. And then I would actually intend to rule on that orally, very likely orally, at the start of the hearing. I know it would be nice to have more notice, but we're up against those deadlines, so that I would rule on that at the start of the hearing. If you're putting on your evidence first, there would be a little time for Marina Coast and City of Marina to sort things out if there was a change in what was planned. So those are my thoughts there. Mr. Spalding, please go ahead.
Yes, thank you. We strongly oppose the motion, which shouldn't be a surprise, but you have just stolen my thunder. I was going to suggest that we file a response and file it by the end of the day tomorrow. So
Good.
Yeah, sounds like a great way to go.
Great, thank you. And Mr. Wilkins, I see you have a hand up and you've been very patient as well. So Mr. Wilkins, do you care to chime in? Or maybe that's my hand. You don't have a hand.
I don't
Sorry.
have a hand up, so.
My cursor turns into a hand. It was randomly located on you. I apologize. So I think where we are right now is that Marina Coast and City of Marina will have until the end of the day Friday to respond to the other elements of the objection that Cal-Am raised, the evidentiary objections that Cal-Am raised in their motion today. And we are planning to reconvene at 9 a.m. tomorrow morning to discuss where we are on some kind of agreement, which I strongly encourage you to work towards diligently on the presentation of rebuttal evidence and what that would include from Cal-Am. And then I think at 9 a.m. we can resolve this issue of exactly how the hearing would be run, whether we want to postpone the start of the hearing until Tuesday morning, whether we need more time to sort things out. And I would appreciate any suggestions from you at that point tomorrow, and we can have hopefully a good understanding of what we're doing next week. Are there any concerns about that proposal and planning to leave things as they are now and reconvene tomorrow morning at 9 o'clock?
No, but for me, I just want to respond to something you said. I understand that they're going to file a brief. Obviously, we may not respond, and I get the relaxed rules associated with these proceedings as governed by the government code, hearsay and the like. I think those don't apply to an entirely new witness. That's just one comment I had to make real quickly.
I appreciate that, Mr. Betts, and I do. And I mean, fundamental standards of fairness apply. It of course apply in these proceedings. So I certainly understand that. All right, with that, I really appreciate the discussion today. I appreciate the time and energy of the experts, particularly in joining us today. With that, I wish you well and good luck, and I will see all of you tomorrow morning at 9 a.m.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.